Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about a new proposal to regulate what the government calls online harm and what this proposal means for freedom of expression in Canada. Now, full disclosure, the charity that I work for, the Canadian Constitution Foundation, has outlined some of our concerns about this proposal, which was announced just before the election was called. The proposal involves regulating the content of online media platforms like Facebook, Instagram, and Twitter for 5 specific types of content: terrorism content, content that incites violence, hate speech, revenge porn, and childhood exploitation images. Now, I'd like to make something clear. This content is abhorrent, and it's already prohibited by the criminal code. But what might be some unintended consequences of the government's new proposal? Today, we'll be speaking with 3 experts: Professor Michael Geist, Jay Goldberg from the Canadian Taxpayers Federation, and lawyer Omar Hawradai. Thank you all so much for joining me today. Professor Geist, I'd like to start with you. You've raised some concerns about regulating this type of content, but isn't this content illegal? Maybe it's a good idea to create a process to remove illegal content online. How do you respond to that?
I think my concerns have been primarily focused on not so much whether we regulate the content, but this particular proposal and how we're going about doing it. I think one of the things that we saw both in the debate around C10 that some of your viewers may recall, as well as this debate, is that there is a tendency at times by the government to try to frame this as either kind of you're with us or you're against us, either you're for regulation or you're against it. And I don't think that that really reflects where the debate is or where the debate ought to be. So it's not about whether or not we ensure that we've got effective tools to deal with content that, as you suggested off the top, is abhorrent. It's whether or not the tools, the new tools that are being introduced, one, are strictly necessary. And we know that we are already dealing in these instances with illegal content, and there are already powers to try to deal with that. And if they're insufficient, then we should be taking action. But we also need to be cognizant of some of the costs and the risks associated with some of these proposals. And I think that that's where the government in this proposal really gets it wrong. I mean, I think it really is very dismissive of some of the core fundamental freedoms, some of the charter rights along the way. And so the pendulum swings so far in the direction of takedown that the result is that it won't just be illegal content that gets caught up, but an assortment of other content, perfectly lawful content as well.
Yeah, so one of the proposals is a 24-hour takedown requirement. Platforms would be required to respond to reports of this content within 24 hours. Now, Mr. Hawradai, do you have any concerns about that takedown requirement? Is it too short and will end up having a chilling effect on speech as these platforms try to avoid penalty and just take down anything that gets reported?
So I agree with Professor Geist about the nature of this debate. I think that it's helpful to avoid the extremes in terms of what we're looking at. But, the question that I would say in response to you, Christine, is even 1 minute or 1 second of child pornography appropriate online? And so, in certain circumstances, it is, I would say, very much justified to have content that is that harmful removed immediately. And when we're dealing with certain industries that have the ability to respond within 24 hours, so be it. And I think the bigger question will be, though, what checks or balances are in place? And after that 24 hours, is there a mechanism to properly challenge and review the way that these powers are being exercised?
Mr. Geist, I just want to give you a chance to respond to that before turning to Mr. Goldberg.
Yeah, I think it's a great point. I think it actually highlights one of the many problems, in my view, with this consultation, and that is that it treats all of this content in precisely the same fashion, as if child pornography is the same as hate speech and is the same as other kinds of images, or the same as all the other kind of things with so-called terrorism content that gets wrapped up in this. And the reality is that they are, while I think clearly would object to all of these forms of content, the tools that we would use to address that kind of content, I think in many ways ought to be different. And without that kind of granularity, by packaging this all together and saying it's all the same, you end up with CSIS-related concerns around terrorism, child pornography concerns, which of course concerns all of us, hate speech, which concerns a whole series of groups that may be themselves the target of these kinds of rules. And so I don't think you end up with an effective mechanism to deal with these issues.
Professor Geist, we've got to go to commercial break. I'll let you finish after this break. Welcome back to Canadian Justice, where we're discussing whether the online regulation of content is warranted or if it's a form of censorship. Now, Professor Geist, I just wanted you to be able to wrap up the point you were making on your last, on the last segment about the differences between these 5 types of harm the government's outlined.
Yeah, I really was just to make the point that, these are hard issues, and the kinds of content that we're talking about, while they may be the same in the sense that there are legal rules around them, they are significantly different, I think, in terms of the kinds of ways we would want to be addressing them. And the government really hasn't, I think, given the kind of seriousness of thought to how you best go about dealing with each of these kinds of content.
Now, Mr. Goldberg, I want to give you a chance here to jump in. What are your main concerns with the federal proposal to regulate online content?
Well, first of all, as Professor Geist has so eloquently said in the past, we might be creating here a new bureaucratic superstructure with creating all these new review boards and tribunals and agencies to try to deal with this. We also have concerns about partiality here. This proposal would create a digital safety commission with a commissioner leading it, who would be appointed by the cabinet, and then a tribunal potentially dealing with what should or should not be taken down, all appointed by the Minister of Heritage. So you're looking at a bunch of people appointed by a partisan government, potentially ordering companies to take material down. And that's a deep concern if there's some material potentially that would, in some cases, be negative toward the government.
Yeah, so what the government has proposed is creating a new regulator, the Digital Safety Commissioner, and 2 other regulatory bodies, actually. It's a huge new bureaucratic endeavor. Mr. Haradai, how do you respond to Jay's concerns he's raised about the partiality of the people who get committed to this new bureaucratic structure that are all going to be partisan selections, or at least have the potential to be partisan selections?
I share those concerns in part simply because we've seen at all levels of government, irrespective of which party, that these types of partisan appointments can and do happen. So it's not an unfounded concern, but as I pointed to earlier, that decisions that are made through bodies like this are subject to review, primarily by judges ultimately who are not elected. And there is a strong measure of independence. It doesn't mean that there aren't different perspectives by judges, but they are politically independent. And that is where many of us have some assurance, at least, that there will be a review process.
Now, Mr. Goldberg, you'd also raised concerns with some of the penalties. Can you outline for our viewers what the penalties are for failing to take down this content?
Yeah, absolutely. So failure to block certain content could lead to a fine of 3% of global revenue, or $10 million, whatever is higher. That's a heck of a lot of money. If you're looking at companies like Facebook and Twitter, that could be billions and billions of dollars. And so if there's that much on the table, then what you could potentially see is these companies realizing that there's this significant risk, not ever really challenging what the government is instructing them to take down, just because they'll be afraid of the magnitude of the fines here.
Now, Professor Geist, platforms already do have their own policies for removing content that would fall under these categories, and probably more content, since a lot of them have these community standards policies. How are those types of policies, these privately developed policies, working, and how effective are they at getting rid of this content?
Well, not well enough. And that's why I think this notion that we don't need rules is incorrect. I do think that we need rules. I think that part of the focus, the extent to which we are focusing specifically on the platforms, has to be on both more transparency in terms of what they do, more consistency in terms of how they apply those rules, because it often feels wildly inconsistent in the ways that they may apply them, and frankly, real accountability where they fail to do so. These companies should be held responsible where they hold out that this is the standards that they have, this is how they're going to enforce it. And when they fail to do so, there ought to be liability associated with that. That's quite different from the kind of plan that we see articulated by the government here, which, as we've been talking about, involves so much of this additional levels of bureaucracy and incentives to remove, as opposed to incentives to be transparent and accountable.
Now, Mr. Haradai, how do you feel about these penalties, and do you think that they're maybe over the top?
Well, I think, again, we're still looking at a discussion paper, not necessarily a bill, definitely not a law. So it is very, very speculative to say whether or not it will be disproportionate. What I would say is that administrative monetary penalties have in other contexts been very effective in modifying the way that private industry does business. And so I'm open to the suggestion. I don't think it's necessarily a door that's fully closed to me.
Okay, well, we will continue this conversation when we come back from these commercial messages. Welcome back to Canadian Justice, where we're talking about new government plans to regulate online content and whether this is warranted or if it's a form of censorship. Now, Mr. Howard, I want to look at how artificial intelligence can be used to implement this 24-hour takedown requirement or proactive monitoring of platforms for harmful content. AI is probably going to be used to implement this. I mean, there's just so much content that these platforms would have to weed through. But do you have any concerns about the government proposal to have proactive reporting to law enforcement and about the use of AI or computer-generated records being sent to law enforcement?
So yeah, it's easy to respond to the concerns that Jay addressed about partisan influence or bias by simply saying we're going to rely on a computer, we're going to rely on an algorithm. Unfortunately, we know that artificial intelligence can and often does amplify and even magnify biases, especially if it is based on data that is created by individuals and from individuals who have biases. And so the nature of law enforcement historically, at least in Canada, does constitute a disproportionate amount of interaction and focus on historically marginalized populations, racialized populations. And so there is a very real concern that using technology in this way that pretends that it isn't biased may in fact accentuate those types of focuses in the future.
Professor Geist, your response to concerns about how AI could be used to implement some of these government proposals, specifically the proactive monitoring and reporting to law enforcement?
Yeah, well, I mean, I think it highlights what we've been talking about. So proactive monitoring, or at least automatic reporting to law enforcement, if you're talking about child pornography, is something I think actually we've had long years of cases where that kind of thing has arisen. It's something quite different, though, when you're engaged in speech. And it's even further different, I think, to Omar's point, once you start using AI as the basis for doing it, because it's sometimes not going to be able to pick up the different kinds of context. And there are the risks of bias. And so part of my concern with frankly, that issue, as well as more broadly some of these issues, is that I think some of the very groups that we are seeking to protect, or the government is seeking to protect with this legislation, may themselves end up being the target. Part of the problem when you have incentives to take down content is the very groups, for example, anti-hate organizers will try to go after the purveyors of hate, will turn around and target those same groups. And the same with AI, where some of the groups we're trying to protect may themselves find themselves caught up in this because some of the bias issues. And so I don't think the government has put forward good answers for how they can distinguish between some of this stuff. But what they have done is create the incentives for these companies to implement these kinds of technological solutions. There's almost no way to live up to the kinds of obligations the government is thinking about without resorting to some of these kinds of technologies.
Yeah, I think for AI, they have a way of digitally marking images, like child exploitation images, that has been used by law enforcement and by platforms in the past. I think Apple's using it now. I don't think that necessarily raises a problem, but when you get into a computer trying to determine how speech is hate or not, when that definition is inherently subjective and courts struggle to determine what's hate, you run into some problems. Mr. Goldberg, I want to turn to you. You have told me, or you've written in the Financial Post, that this proposal is a kind of censorship targeted more at free speech than at harmful speech. Can you tell me what you mean there?
So what I mean by that is that this proposal is essentially through the Ministry of Heritage. And, all of these issues, as you've said before, terrorism or child pornography, absolutely abhorrent. And, we should have law enforcement go after it. I think we need to have a conversation in this country about whether or not criminal code needs to be strengthened or additional powers we can give law enforcement to try to go after some of these issues. I think it's concerning when it's just coming out of the Ministry of Heritage, as they have nothing directly to do with law enforcement. And so I think we would be better off with a proposal that would go through the Ministry of Justice and potentially find ways to help law enforcement deal with these issues.
Omar, in about 30 seconds, how do you respond to that concern?
Well, I think the problem with, let's say, harmful expression in Canada goes beyond justice concerns. And so I understand as part of a broader initiative why this is coming out of Heritage. We've talked about in previous episodes about French language content and our bilingual nature that distinguishes us from the US. So I think there does need to be an integrated strategy from the government, and that's why you're seeing different ministries involved.
Well, we will continue this conversation when we're back from these commercial messages. I want to talk about some of the other details of this plan, which is a pretty all-encompassing plan. It's a pretty big proposal by this government. We will be right back. Welcome back to Canadian Justice, where we're talking about the government proposal to regulate online harm and whether it's a form of censorship. Now, Professor Geist, one of the concerns that you've raised is that the new regulator, the Digital Recourse Council of Canada, could run what you call secret hearings and order content to be taken down. Can you explain what's going on with that proposal?
Sure. So, so we've already referenced the fact that the government is thinking about really a regulatory superstructure with a digital safety commissioner, with the Digital Recourse Council of Canada, which is effectively a content tribunal making decisions on when content goes up or down. And they are actually layering in powers for the CRTC, powers for a new privacy tribunal that was contemplated in another piece of legislation. Within the proposed document, in the document that sets out the proposal, they talk about the kind of rules that would govern the Digital Recourse Council and say that there may be instances where some of those hearings will be conducted and in secret. And I have to say that, the sort of as a, even just seeing that put forward, where you are vesting power in this council to make decisions about what content is viewed as illegal or legal, goes up or goes down, and opening the door to saying, well, we may not even allow the public into those kinds of discussions. It will be conducted in secret. I don't think will sit well with a lot of people. And they may say that, listen, there's perfectly good reasons for that. It may be that we're dealing with, let's say child endangerment type cases, and we want to ensure that information is not made public. But that again, I guess, yet again, reemphasizes just how poorly thought out this is if what you are trying to do is grapple with all of these different kinds of content using the same kind of blunt hammer in effect. And what you end up with is the risk that, rather than those kinds of cases, what happens if we start having cases where it really is sort of some of these borderline type speech cases where it may be illegal, it may not be illegal. The idea that we would hold those hearings in secret to make that kind of determination by these unelected appointed bodies, even with court oversight, is still, I think, pretty striking and troubling.
Yeah, I mean, there's a lot of nuance here that can't be captured by treating all this content the same. Mr. Haradai, the government has also said that they're not going to be applying these laws or these proposals to private communications. But many private platforms, for example, WhatsApp or Skype, are actually used as social platforms if the chat groups get large enough. Do you think that those platforms should be subject to the regulation, or do you think they could be in the future?
I think they could be, and perhaps in some cases should be, and maybe it's worth explaining why.
I mean, that's a big proposal, right? Like, these are private chat groups, right?
Yeah, but if you have a chat group with 500 people, then is it really a chat group? And if you have, like, let's say, a show that you're effectively doing on a chat group every week, is it just a private communication? And I think I distinguish that enormously from a one-on-one conversation that someone's having, which is more akin to a conversation that you're having in your home. You're actually allowed in Canadian law to say hateful things in your home to another person. But if you go walking down the main street with that sign saying exactly the same message, you may be running afoul of human rights and criminal code provisions. And so there is a distinction there. I think we're all trying to figure out how to apply these historic notions of law that have always existed. I think we need to be clear about that. We've always tackled with these issues. We're struggling with how to tackle and deal with them in a new format, in a new medium. And I agree with Professor Geist that balance is going to be a tricky one.
Mr. Goldberg, we've got about 10 seconds. This bureaucratic superstructure, who's going to pay for it?
Taxpayers are going to pay for it. We're going to see new regulatory charges charged to these companies, but of course we know that they're always passed down to the consumer.
Well, that's all the time we have today. I want to thank you all so much for joining me. We've heard today about the new federal government's proposal to regulate online content, including a 24-hour takedown requirement, a new bureaucratic superstructure of regulators, secret hearings, website blocking orders, and even warrantless searches. The proposal is not yet a law or even a bill. So far, it's just a technical paper and discussion guide. The government calls it a consultation, although there really isn't much of an obvious place for Canadians to provide input, aside from an email address, which I've listed on the screen below. You can send in your concerns by writing a letter to the Digital Citizen Initiative. As I mentioned at the beginning of this segment, the charity I work for, the Canadian Constitution Foundation, is very concerned about the implications of this proposal, and we've created a sample letter, which you can find at the ccf.ca/no-gov-censorship. Please feel free to modify it to express your concerns as you see fit. That's all for this episode of Canadian Justice. Thanks for tuning in, and remember, a freer Canada starts with you.